इंट्रिंसिक एड ऑफ इंटरप्रिटेशन। एक्सटर्नल में मेन अपने पास 1 2 3 4 5 6 7 8 आते हैं। पार्लियामेंट्री हिस्ट्री, इसमें पार्लियामेंट की हिस्ट्री बताई जाती है। टेक फैक्ट हिस्ट्री और हिस्टोरिकल फैक्ट्स एंड सर्कमस्टांसेस। डिक्शनरी, फॉरेन लॉ एंड जजमेंट्स, अदर स्टैट्यूट्स, टेक्स्ट बुक्स, लेजिस्लेटिव डिबेट्स एंड स्पीच, कमिटीज रिपोर्ट। तो सबसे पहले अपनी आ गई डिक्शनरी, टेक्स्ट बुक, अदर स्टैट्यूट्स, हिस्टोरिकल फैक्ट्स, पार्लियामेंट हिस्ट्री, लेजिस्लेटिव डिबेट्स एंड कमेटी रिपोर्ट। उसके बाद अपने आते हैं इंटरनल्स। फॉर असिस्टेंस इन इंटरप्रिटेशन, कोर्ट कैन टेक हेल्प फ्रॉम द विद इन द स्टैट्यूट्स और इवन आउटसाइड। तो इसमें मेजरली अपने पास है टाइटल, जिसमें 2 आते हैं, लॉन्ग टाइटल, शॉर्ट टाइटल, देन प्रीएम्बल विच एम्स एंड ऑब्जेक्टिव सॉर्ट बाय इट, then headings or prefix to section of groups of section. D, marginal words which are nothing but a side notes. E is illustration are patented in the section. F is punctuations. Sometimes courts avoid those punctuations, sometimes court consider those punctuations. G is proviso, which is a clause which is added to the statute to accept something from enacting clause or to limit its applicability. Then there are some definition or interpretation clause also and explanation also, which is contained in the statutory acts. Then schedules and punctuation, we have already covered this. Then next one is interpretation and rules. So as per Salman, interpretation is the process by which court seeks to ascertain the meaning of legislation through the medium of authoritative form in which it is expressed. So Salman defines it like interpretation. It is the process by which court seeks to ascertain the meaning of legislation through the medium of authoritative form in which it is expressed. So, but those interpretation usage not mandatory but discretionary. So rules, court may or may not use it. Whichever rule they feel is apt for the case at hand, they should opt for it. There are majorly three rule of interpretation that are uh, literal rule of interpretation, golden rule of interpretation, mischief rule of interpretation. Then in penal and taxing statute, the court does not have the option to apt for the rules of interpretation. They have to follow it religiously. So therefore, for those statute, they need to follow it strictly, or as per they have to take the literal interpretation instead of other rules. So first and foremost thing is penal statute, which defines a criminal offense and prescribe its corresponding penalty, which penalty may include fine or imprisonment. Then taxing statute look at what is clearly said. There is no equity about a tax, so no indentment, no presumption, no implication. So strict construction should be there. Complements the rule of lenity, which is formed by Lord Asher, which says that legislative ambiguity in a criminal taxing statute should be resolved in favor of the defendant if it is not contrary to the legislative intent. So penal provision in tax statute should be strictly construed. For appeal, provision creating rights and refund, liberal construction in favor of SSC only. So for example, two exempting sections are there. SSC can choose to fall in both unless they are made mutually exclusive by express provision or necessary implication. So it is cannot be presumed to have retrospective operation. So there are few case laws also. First case law is Commissioner of Custom Import Mumbai versus Dilip Kumar and Company and ORS 2018 का case है Supreme Court, where it says that this case law is related to tax exemption notification. where court held that strictly interpretation or strictly the rules or the exemption should be strictly interpreted, otherwise um, it will lead to many innocent might okay or else many innocent might become victims of discretionary decision making. So therefore it cannot be expanded interpreted to include those which were not intended by the legislation. Second case law is of state of Punjab and Ram versus Ram Singh in 1922. This constable was caught wandering in a public spot with a gun while it was intoxicated on the duty. During a medical check, also he abused a doctor. So it was determined that the policeman was capable of committing the most crime as a result of his drinking, and the Supreme Court construed strict construction in accordance with Maxwell standards, which are based on the seriousness of penal legislation, and found it is justified to punish him for his misbehavior. The third case law is related to state of Jharkhand versus Ambe Cement, 2005, where exemption clause must be rigorously construed on the conditions specified. So therefore, the condition mentioned in the statute are required by the law, and it is mandatory as a course of action but not discretionary. Where legislation is a criminal in nature, it must be rigidly construed and obeyed. The next case law is Bakhtawat Singh and Balwant Singh, 1927. The Allahabad High Court held that if punishment has been issued for failing to observe the requirement of any legislation, it shall be construed strictly. So now we are going to read literal or grammatical interpretation, which says like it is a plain meaning. So the law should be construed as a plain meaning of text as it is. So it is also called as plain meaning rule. When provision does not give rise to more than one meaning, this rule should be adopted by the court. So one of the case law, famous case law is DuPont Steel Limited. So this rule focus on not looking at the intent of the lawmaker or spirit of the law. So it is a strict construction, strictly construed, which is opposite to the liberal construction. Next rule is mischievous rule. It was developed in hidden case in 1584, where it was discussed that rule of purposive discussion or purposive construction purpose of the statute is most important. So why this statute came to existence is the most important thing for this rule. So while having discussion for this rule prevents the misuse of provision, and it should be ensured that it should not add to mischief to a statute. So it is there to stop the mischief, not to add to it. So wherever you will see the taxing and penal statute are strictly construed, it is this rule is not applicable to those taxing and penal statutes. This mischievous rule is construed on most of the beneficial legislation, which is beneficial for the employee or SSC. Those statutes are like Employee State Insurance Act, Contract Labor Act, EPF, that is Employees Provident Fund Act. So those laws should be liberally construed. Even in case of taxing statute, beneficial provision should be liberally construed. Statutory construction in welfare legislation is construed liberally in purposive manner, which effectuates the object. The famous case law is Bengal Immunity Company versus State of Bihar. Next one is Golden Rule. Golden Rule is which means that it needs to modify the meaning of the observed term to give its useful and apt meaning to suit the context. So when the language of the statute is ambiguous or grammatically incorrect, this rule is applicable. When the literal rule fails due to existence of multiple meaning of a word in the statute, the golden rule is to be applied and should not may lead to judicial criticism of the correctness of the act of legislature. So in this golden rule, two approach have been followed. First one is narrowed down approach, and second one is a broadened approach. Narrow down approach is where the two or more multiple meanings are available in the from can be interpreted from the statute. The court may narrow down the meaning of that particular word in the statute, and therefore narrow down approach can be taken. The second approach is broaden approach, where the word is have their own limited use, but court has taken an option to broaden the meaning of that particular word. So therefore the broaden approach can also be adopted by the this, respective courts. So it takes away the requirement of amending the legislation. So if the court is adding or amending or narrow down the approach of that particular word, there is no need to amending the law, and the court can suo moto change the meaning of that particular word through this golden rule. So it was formed by Justin Holmes, also Justice Holmes. The famous case law is State Bank of India versus Sri and Sundaramani, 1976, statute considered as repugnant. Repugnant means waste or wrong. The another case law is State of Punjab versus Qasir Jahan Begum, 1963, where the period of limitation will start from getting knowledge of award instead of notice of sale of land. Next case law is RBI versus Peerless General Finance and Investment Company Limited by the Supreme Court. The next maxim is peri materia. Peri materia means of the same subject matter. So it is a tool to interpret the statute having the object of having the same objectives, like what has been held in the case law of JK Steel Company in the case of Supreme Court, where the Central Excise and Salt Act found to be have same objective, and where it is construed according to that. When different statute used in for common objective, subject matter to know the true intent of the legislation. Next one is judicial activism. Judicial activism signifies the proactive role of the judiciary in protecting the rights of citizens originated and developed in the USA. So this is kind of judicial activism where signifies the proactive role of judiciary in the protecting of rights of citizens. So this rule was originated and developed in the USA, opposite of judicial restraint. In India, the Supreme Court and the High Courts are vested with this power. They can examine the constitutionality of any law, and if such law found to be consistent with the provision of the Constitution, the court can declare the law as unconstitutional. So if this law is inconsistent, the court can declare the law as unconstitutional, and subordinate court do not have the power to review the constitutionality of laws. So we can say that judicial activism is kind of a judicial review. So next section is of judicial review, which is covered under Article 372 subclause 1 of the Constitution, which says that judicial review is the power of the court to determine the constitutionality of legislative act in a case constituted by a aggrieved person. It is the power of the court to declare a legislative act void on the grounds of constitutionality. Parliament pass laws. Union and state has the power to make the law. Supreme Court and High Courts are constituted the protector and grantor of fundamental rights under Article 32 and 226. Article 251 and 254 says that in case of inconsistency between the union and state laws, the state laws shall be void. So there are majorly three types of judicial review. First one is constitutional amendment. So judicial review of constitutional amendment, judicial review of legislature of parliament and state legislature, and third one is judicial review of admin action of union and state government. Doctrine of eclipse. Doctrine of eclipse covered under Article 13 of the Constitution, which says that laws inconsistent with Part 3 will be considered as void, remain unforeseeable because it is contrary to the fundamental right. It covers non-citizen also. If the action of the delegated legislative body affects the fundamental right granted to the people, then it is said to be ultra vires to the constitution, and ultra vires is an error apparent on the face of the record. The lack of jurisdiction of any delegated body forms the error on record. Next one is type of statutes. So there are 8 types of statutes, which are enabling, which removes of restriction or disability. Second one is disabling or restrain on alienation of property. Third one is amendment. This is when the judge or legislature changes or alter the statute law, like Company Amendment Act 2013. Fourth one is consolidation. This is combining several previous statutes relating to the same subject matter with or without making changes in the same. GST Act 2017. Remedial Act. This is when they alter the common law or the judge makes a non-statutory law on a particular subject. Sixth one is penal, when there is imposition of penalty or forfeiture. IPC 1860. Codification. It is one when they codify the unwritten law on a particular subject. CRPC 1973. Declaration, when there is no change in the existing law but merely clarification or explanation of what it is. The Registration Act 1908. So next question, general principle of interpretation. So majorly there are 2 principle of interpretation. First one is a primary rule, second one is other rules, which are known as secondary rules. The primary rules are literal interpretation, the mischief rule, Haydn's rule, rule of reasonable construction or ut res magis valentquam periat, rule of harmonious construction, rule of justum generis. Statute must be read as a whole. The other rules are expressio unitis est exclusio alteris, contemporanea expositio est optima et fortissima in legi, nocitur e socis, a strict and liberal construction. Rule of harmonious constructions. Simple premise is every statute has a purpose and intent as per law and should be read as a whole. Interpretation consistent of all the provisions of the statute should be adopted. In the case in which it shall be possible to harmonize both the provisions, the court decision should regarding the provision shall prevail. Next one is statute must be read as a whole. This is the rule of law. It is one of the most important rule of interpretation. The statute must be read as whole means a provision cannot be read or understood partially. We cannot understand the intention of the legislature behind making of the law if we do not read the statute as a whole. A provision cannot be interpreted in isolation. Sometimes the meaning of the words used in the section may be understood with the help of the other words used in the same section. Expressio unis est exclusio alteris, which means that express mention of one thing implies the exclusion of other. Maxim ought not to be applied when its application leads to inconsistency or injustice. Contemporanea expositio est optima et fortissima in lege. Contemporaneous exposition is the best and strongest in law, where the words used in the statute have undergone alteration in meaning in the course of the time. The words will be construed to bear the same meaning as they had when the statute was passed on the principle expressed in the maxim. Nocitur e socis means it is known by its associates. Rule of justum generis. A use them generis, identical expression of the same word. Of the same kind, words of similar class. where one word is ambiguous and inherently unclear, then it should be restricted to that genus. Where particular words have a common characteristics and general words that follow should be construed as referring generally to that class, no wider construction should be afforded. General words should be given their natural meaning like other words unless the context requires otherwise. But when a general word follows specific words of a distinct category, the general word may be given a restricted meaning of the same category. This rule is applied with a great caution because it implies a departure from the natural meaning of the words in order to give them a meaning on supposed intention of the legislature. Their color and their intents or contents are to be derived from their context. The famous case law is Maharashtra University of Health and others versus Sachikitsa Prasarak Mandal and others. University of Madras versus Shantabai. Word other authorities means authorities carrying state functions only. So example is if lawmaker refers to automobile, trucks, tractors, motorcycle and other motor powered vehicle, the vehicles would not include airplanes since the list uh, of motor vehicle was related to land based transportation. Nocito res case. Meaning of a word should be known from its accompanying or associating words. It is to be read in collocation with its companion words in cognate sense. The same words bear the same meaning in the same statute. The following rule will not apply. Rule will not apply when the context excludes the principle. A sufficient reason can be assigned and it is proper to construe a word one part of the act in different sense from that which it bears in another part of the act, where it would cause injustice or absurdity, whether the different circumstances are being dealt with, whether the words are used in a different context. Many do not distinguish between this rule and a justum generis doctrine, but there is a subtle distinction as pointed out in the case of State of Bombay versus Hospital Mazdoor Sabha. Doctrine of retrospective operation of statutes. Article 20, subclause 1. No retrospective impact of the formulated laws on offence committed, not to be given to a statute so as to impair an existing right or obligation. Prohibited for any civil offence because it is unconstitutional as well as void. Constitution of India does not permit a retrospective operation generally. Example is GST amnesty scheme 2022 or Vodafone case. Karnataka's scheduled caste and scheduled tribe prohibited of transfer of certain lands Act 1978, which was retrospective in nature. This act aimed to prohibit the transfer of land granted by the government to people belonging to the scheduled caste and scheduled tribes. This law was also applicable on the land under the ownership of the scheduled caste and scheduled tribes before the enactment of the law. Nobody was even allowed to purchase the land owned by the belonging to the people which pertains to scheduled caste and scheduled tribe communities. Doctrine of colorable legislation. It means that if a legislation lacks the jurisdiction to enact laws on a specific subject directly, it cannot make laws on it indirectly. In other words, the doctrine checks if a law has been acted on a subject indirectly when it is barred to legislate on that topic directly. This is designated to prevent the legislator from doing anything that has been explicitly forbidden from being done indirectly or secretly. The expression colorable legislation means that what cannot be done indirectly cannot be done indirectly as well. Delegated legislation and ultra virus. Article 245, Doctrine of Territorial Nexus. According to the Doctrine of Territorial Nexus, laws made by a state legislature are not applicable outside that state except when there is a sufficient nexus between the state and its object. This doctrine derives its authority from Article 245 of the Indian Constitution. Article 246, 7th schedule contains three lists for powers. List 1 for union, list 2 for state, list 3 for concurrent, state and central. So it conclude it include intra-virus and ultra-virus. Intra-virus means within the power, ultra-virus means beyond the power. Ultra-virus to the constitution power are error or excess of initial jurisdiction, error or loss of jurisdiction on the way of proceedings or the pending proceedings, malafide intention or improper motive, mixed consideration or irrelevant consideration, which means that power confirmed is exercised with a different purpose deviating from the actual purpose, and error apparent on the face of the record. So due to those reasons, the act can be said as ultra vires of the constitution of power. Doctrine of pith and substance. Court uses real essence of registration, not applicability. So it could be conflicting because ancillary incident of encroachment of power of law making can happen. So this rule is adopted. It is so that it will not result into invalid or void law and avoid limitation on the power of legislatures. It determine true nature and character of the subject and decide the list which under it falls. Flexibility to the power of state legislation and saves power by providing additional validation. Case is Bank of Commerce Khulna. Rule of law. It is one of the most important rule of interpretation. The statute must be read as whole means a provision cannot be read partially or incompletely. We cannot understand the intention of legislature behind making of that law if we do not read the statute as whole. The provision cannot be interpreted in isolation. Redendo singula singulis. Where a complex sentence has more than one subject and more than one object, it may be right construction to provide each to each by reading the provision distributively and applying each object to its appropriate subject. For instance, if anyone shall draw or load any sword or gun, the word draw is applied to sword only and the word load to gun only. The former verb to former noun and later to later, because it is impossible to load a sword or to draw a gun, and so of other applications of different sets of word to one another. Construction in bonum partem. This is a Latin maxim which means that words used in a statute are to be taken in their lawful sense. Thus, lawful means that it is not prohibited by law, legitimate. It follows, therefore, that word must be construed in their lawful sense. Construction in bonum partem. In case of seizure of the debtor's good, it must be lawful seized. Similarly, when the demolition of a part of building is ordered by the corporation, it must be demolished lawfully. Statutory discretion. So, discretionary interpretation is a process that is needed to be declared inevitable by the court. Judges should have the freedom to declare that the statute interpreted in a conventional method is sufficient or a prudent discretionary interpretation is necessary to reach a fruitful conclusion. The absence of such freedom creates serious difficulties in the lawmaking. The research paper will focus on how a doctrine of discretionary interpretation would work in actual practice and how it would improve the interpretative process. Doctrine of delegation in case of vicarious responsibility. Every person is liable for acts and the person commits and not liable for the acts done by others, but in some situation when a person is liable for the acts of another person is known as vicarious liability. So for this to happen, there must be specific kind of relationship between both the people, and the act must be connected with the relationship. These relationships can be a master and servant or principal and agent. Qui facet per se per alium facet per se, which means he who does an act through another is deemed in law to do it himself. Instance Salman Khan case. Applicability of conclusive evidence clause. It provides that the court may presume the existence of certain facts that should occur in the normal course of natural phenomena, human action, and public and private business without requiring proof. Section 112 and 113 of Indian Evidence Act, 112 legal son of married man, and 113 cessation of territory. खत्म चलो सौंदो
खत्म
हाँ
ਤੁਸੀਂ ਰੀਡ ਕੀਤਾ ਬਸ
हाँ
ਰੀਡ ਕੀਤਾ